Hello, my name is Steve Wallace, and this is my presentation for tort liability for my EDL 850 School Law class, Module 12. What is tort liability? Tort liability covers a lot of things. I didn't really understand how many things actually fit under tort. So tort action is an actionable or civil wrong committed against one person by another that is independent of contract. There's two different types, intentional and unintentional, which I'll get to on the next couple of slides. So if an injury occurs as a result of actions of school personnel, liability charges will most likely be imminent. The liability may result in deliberate acts committed by another or acts involving negligence, and we'll talk more about negligence as we go through this. One important thing to remember, if you're a certified personnel, there's a thing called in loco parentis, which means in place of parents. So once the teacher is in charge of the student, they're given three duties. That's to instruct, supervise, and provide safety to the students. That safety part is where a lot of these court cases come up. A lot of the tort law comes into play, is providing safety to students. Intentional torts. So this is a lot of things that you read about in the paper that happen on an everyday basis, which require proof of intent or willfulness. So that includes things assault, battery, libel, slander, and so on. A lot of those things that you think of when you think of criminal law. Unintentional tort does not require proof of intent or willfulness, and the basic example for that is negligence. You didn't do something that you should have done, which resulted in an injury. Let's talk about our first court case of 5. This is Frame versus Comey in 1999. Frame was an 8th grade student. Comey was a substitute teacher. The substitute teacher was asked to give a test. There was a group of students that were being not behaving correctly. He removed those students from class. A little while went on in class. Frame spoke aloud during the test. The substitute teacher asked Frame to leave the classroom 2 times. The student refused. The substitute teacher then approached the student. The student then stood and it kind of got into a confrontation. Substitute teacher grabbed the student's arm to remove him from class. When he did that, the student fell back and stumbled into the blackboard. So in this case, the substitute teacher was accused of assault and battery due to the physicalness of what happened in the classroom. The court found that although battery was committed, it was necessary in order to maintain order and facilitate the learning process. I was a little surprised by the outcome of this. I thought, touching a student would probably fall in favor of the student. Evaluation of this case, if it happened at my school, the teacher would most likely be put on leave and investigation would occur. Since it was a substitute teacher, I would think they would probably be let go from their duties as a substitute. Proactive measures, providing education about laws to substitutes in the districts. I've been a substitute. Not one district has ever given me any sort of education on how to handle students. And then as a teacher, you might not want to give anything that's high stakes like a test that could cause anxiety levels and emotions to be at a high. Describe professional ethics. Treat others how you would want to be treated. That goes for students and teachers. Would you want somebody to put their hands on your kid? Call down to the office for help, especially as a substitute or even as a gen ed teacher. If you need help, call for help before touching a student. Next court case, Flanagan versus Canton, 2009. Flanagan was a 5th grade student. Canton is a school district. The students were acting rowdy in a PE class, showing some very poor behavior. The PE teacher ended class early, lectured the entire class, then sent everyone to the locker room a little early. He decided to pull one student to the side and speak with them directly away from the rest of the group. The students went into the locker room. It was unsupervised. During that unsupervised time, Flanagan fifth grade student was pushed in the back, fell into the locker room bench and locker, causing serious injury, including a splendidectomy. So in the court case, Canton was accused of neglect of supervision. In this case, the court found that Canton was negligent because the behavior of the students made the act foreseeable and should have been provided more supervision. So what this key term here is foreseeable. Since the kids were already acting up, the teacher should have known that there might be an issue if left alone, especially in a locker room situation, and should have been in the locker room because he could have foreseen a problem happening, even though he was trying to deal with a student. Evaluation of this case, if this happened, I think the school district would support the teacher. The teacher was trying to do the right thing, which is correct the behavior, and then correct the behavior of an individual student, just did not choose wisely on when and where to do that. Proactive measures, have a conversation with the student either in the locker room or after the class. Send students in separate groups, separating what the problem is, so that it doesn't carry over into the locker room, and maybe ask another teacher for help that was on plan if it was turning into quite a behavior issue, especially in the PE setting when just the general dynamic of the class is different because it's physical, it's competitive, and being a PE teacher, I really enjoyed reading about this case. Describe professional ethics. As a PE teacher, you got to make supervision and safety a major priority. You should have eyes on all kids at all times and make sure they're in a safe environment. The next three cases, I decided to pick cases that were in Kansas because that's where I teach, so I thought they would be very valid for me. So in this case, it was Sanchez versus USD 469. Sanchez is a middle school student. USD 469 is Lansing School District. Sanchez was a new student that was being bullied continually. One student talked about his lazy eye and made fun of him in other ways, physically threatened him. That student was suspended. Some bullying continued through other students, like, oh, don't let that kid around me or I'm going to beat him up type stuff. Another kid entered the picture, started bullying Sanchez, actually hit him in the face and broke his jaw. At that point, Sanchez left the school district and did homeschooling, and the student that hit Sanchez was expelled for the rest of the semester. In this court case, the accusation that the middle school principal and the school district did not provide a safe learning environment because they did not reasonably and promptly respond to bullying. So in this court case, the principal did suspend students, did have conversations with students, did have conversations with teachers, did do check-ins with Sanchez. And the court found that the principal was not liable due to the Paul D. Coverdale Teacher Protection Act. The Court of Appeals stated that the district was not protected and it was sent back to lower court. I did not see the final decision, but I thought this was an important case because of this Paul D. Coverdale Teacher Protection Act, which came into play during the No Child Left Behind, I believe in 2001. It immunizes teachers. Administrators are included in that, a lot of different personnel, from liability when the reasonable actions to maintain order, discipline, and appropriate educational environment. So in this case, the principal was covered due to this Coverdale Teacher Protection Act from being involved in the court case. Evaluation, what reactive measures? Students would be suspended based on the school handbook. Teachers would be warned and put on alert for behaviors involving these students in the classroom and outside the classroom. And admin would have to take measures to do things before school, after school, and passing periods to make sure those areas were covered. Proactive measures, again, supervision of the commons area, of hallways, those types of things before and after school, lunchtime, and definitely keep an eye on that specific kid from being bullied. Educate the staff and students on bullying and what the consequences of such things are. Describe how the professional ethics, just the golden rule, treat others how you would want to be treated. If Sanchez was your son, how would you want the situation handled? And how would you want the kids that were bullying handled. So, treat others how you would want to be treated and try to educate those kids on responsible behavior. Glazer versus USD 253, 2001. Glazer was a 7th grade student. USD 253 is the Emporia School District in Kansas. So before school, Glazer was being chased by a student on unsupervised school grounds. Glazer ran into a public street and was hit by a car, sustaining injuries. In this court case, USD 253 was accused of not providing adequate supervision. The court found that the school district was not under the control or custody of the student at the time of the incident. Thus, the school district did not have a duty to provide supervision. So, in their policies, they had stated that the student was not under the school's supervision until the student entered the school, and they had not shown any precedent of supervising before school activities. So the court found that the district was not at fault. So reactive measures, if this happened in my district, this one was really hard for me to tell because of this court case that shows that supervision was not needed. I don't know if medical bills would have been paid just to make sure there was no legal case in this. That one was hard for me to answer. I would hope medical bills would be paid for, but maybe not, according to this case. Proactive measures, have certain areas supervised before and after school. Maybe teachers rotate or admins in charge of it. A certain amount of time before school and a certain amount of time after school, because we do want to keep the kids safe, even though, according to law, parents are actually in custody and under the supervision of their child during this time before and after school. It would probably be best practice to supervise that. And then professional ethics, just be prepared for worst case scenarios. Be prepared to provide the best safety for your students, as well as medical first aid, because you never know what might happen in your presence where you need to know CPR or basic first aid. And the last case I chose this because it was actually referenced in the previous two cases, so I thought it's probably a pretty important case in Kansas, and it touched into the U.S. appeals. So in this case, it was Grider, 8th grade student, versus USD 512, which is the Shawnee Mission School District in Kansas. Grider is a SPED student with an IEP. He was put in a woodworking class where he was injured using a table saw. In this case, USD 512 and the teacher was accused of negligence. Negligence in several different ways. One being that the teacher was not provided information about the student's IEP. The student was not given safety protocol using the equipment, and the student probably should not have been in the class according to the IEP. So the court found that so why this was important is this KTCA. The court found that the school district was not immune of KTCA, which stands for Court Tort Claims Act, because the acts were discretionary. So discretionary meaning that the student should have been given the safety protocol on how to use the equipment and was not. So that did not provide them with this. The government entity, which could be a school, or an employee acting within the scope of the employee's employment, shall not be liable for damages resulting in any claim based upon the exercise or performance or failure to exercise or perform a discretionary function or duty on the part of a governmental entity or employee, whether or not the discretion is abused and regardless of the level of discretion involved. So in this case, the students were not provided what they needed to be provided. If the safety protocol would have been given, it might have fallen under the KTCA. What would happen is reactive measures: pay for medical bills, investigate SPED protocols and safety protocols, SPED making sure students are in the classes they should be in, and following the IEP, making sure that IEPs are communicated, as well as safety protocols given by teachers. Prepare a professional in a dangerous classroom setting would probably be a preventive measure, and put student safety first as a professional ethic. Thanks for watching.